Welcome to the Evidence to Impact podcast, the podcast that brings together academic researchers, government partners, and others outside of academia to talk about research insights and real-world policy solutions in Pennsylvania and beyond. I'm Michael Donovan, the Director of Policy and Outreach at Penn State's Administrative Data Accelerator.
In this episode, we'll be discussing criminal justice and sentencing guidelines. Today, my hosts are Jeff Ulmer, Professor of Sociology and Criminology in the College of Liberal Arts, and Mark Bergstrom, Executive Director of the Pennsylvania Commission on Sentencing. Perhaps we can start with a little bit of a background. Mark?
Sure. I started working in probation and parole in the early 80s and came here to Penn State in 1992 as part of the Commission on Sentencing. And then in 1998, I took over as Executive Director of the Commission, and so have been here ever since.
Great. Jeff?
I got my PhD here at Penn State in 1993, and I was a postdoctoral researcher at the Pennsylvania Commission on Sentencing for a year.
Excellent.
From 93 to 94. And then I went to Purdue University as my first academic job. And then I came back here to Penn State in 2000, and I've been here ever since. And my background with this subject is I've literally studied it my whole career from graduate school on. My main research focus, not only, but main research focus has been courts and sentencing, primarily studying Pennsylvania and the federal system, federal courts and sentencing guidelines.
Excellent. So we really have a wealth of knowledge and experience here. So who wants to start here with an explanation just really what sentencing guidelines are and how they impact our society and why they really matter?
Sure. Well, I'll start, I guess. So just as a little background on the Commission, we're a legislative agency, an agency of the General Assembly of Pennsylvania, and we have an affiliation with Penn State, and that affiliation goes back to the early 80s. But we have a formal MOU with the Criminology Department and the College of the Liberal Arts. And so that gives us this wealth of access to people like Jeff and others in the department to help us really work with the data that we can collect and use it to inform sentencing policy. So getting to guidelines themselves, back in the 70s in Pennsylvania, there was a discussion about how do you promote more uniform sentencing. And there weren't a lot of models out there, but the two models that were discussed was enacting a bunch of mandatory minimum sentences or creating a commission that developed guidelines. And guidelines would be a bit more advisory or a little bit easier for judges to consider. And there are two factors that are generally in play in guidelines. The first and probably most important factor is what has the person been convicted of? Because that really creates the boundaries around what kind of punishment or what kind of sentence can be imposed. But another factor that's very important is the person's background. And we generally think of that in terms of criminal history. Has the person been convicted of previous offenses? How many? How serious? And so forth. Now, there's going to be other factors to take into account, but the idea around sentencing guidelines was to promote greater proportionality in sentencing and greater uniformity. And we generally refer to it as a common starting point. We're giving all judges in the Commonwealth a common starting point based on a number of objective factors, and that's where they start sentencing. But then they have to individualize the sentence. They have to look at the person before them and decide if that starting point is appropriate or if there's factors that would move the court in one direction or the other in terms of the sentence imposed. So that's in a nutshell, I guess, what guidelines are. What you'll find across the country is there's a real continuum of guidelines down at sort of the voluntary end where they're there, but courts really don't have to consider them, and at the very presumptive end where they're like mandatories, where judges have a tough time not abiding by the guidelines. We're somewhere in the middle. We're advisory guidelines, but we do have appellate review, and there's other kind of factors that promote compliance with the guidelines, but courts certainly have the ability to depart from the guidelines for appropriate reasons.
Great. Jeff, anything to add on that from an academic perspective?
Yes, well, I think, and I've always felt that, apart from the fact that I have worked with the Pennsylvania Commission on Sentencing U.S. Sentencing Commission as a researcher, but even if I hadn't, I have always thought that sentencing guidelines were the best way, the best approach, have the best promise to structure sentencing and achieve what we want with sentencing. Sentencing and criminal justice decision-making in general always entails a balance between individualization and uniformity, like Mark said. Discretion to tailor decisions, sentences to the needs of the situation, the defendant, the victim, the case, versus the kind of possibility for bias and disparity and arbitrariness and courts doing whatever they want. And guidelines are, I think, the best tool that we've come up with to strike that balance, because they make really good sense in terms of how people and organizations make decisions. They give an anchoring point, like Mark said, a starting point, a benchmark that can then be adjusted up and down. And guidelines also give a range of sentences. They don't just tell the court, hey, this is the sentence. They give a range, and with other considerations to factor in, like aggravating circumstances, mitigating circumstances, and so forth. And so it gives kind of structured decision-making tools, but it doesn't take away the discretion. And so, we talk about unwarranted disparity, meaning unlike crimes and defendants getting, similarly situated defendants and crimes getting wildly different sentences. Yeah. But there's also unwanted parity. There's unwanted sameness, where you have people that are, really different in their culpability and criminality and so forth, getting the same sentence when, it might not be appropriate for one of them. Mm-hmm. And guidelines are the best tool to do that, much more so than mandatory minimums or other things that we've come up with. So that's my that's a favorable view of guidelines, but I think it's, I came to it for sociological reasons.
Sure. And I think that the what is actually perceived as a feature is the discretion built in to adapt to the circumstances. Mm-hmm. But I think that's also what many in the external audience see as a bug, right? Mm-hmm. A problem. Mm-hmm. We're seeing this in current events here in mid-February of 2020 on the national level, as there's been a wide discussion of uneven distribution of justice and sentencing guidelines and coming from the White House. So it's interesting to think about how that is almost never going to make everyone satisfied.
Sure, and I think, as Jeff and I both said, I think there's always this tension between uniformity and individualization, and there's a number of factors that go to the individualization that I think if the public more generally thought about those factors, might see why the discretion is necessary and why you might have different outcomes. So I think about three factors that contribute to those kind of differences. So the one is the offense itself. You can think about an offense in statute that someone has been convicted of. There's proof beyond the reasonable doubt of elements of a crime. But the nature, as Jeff said, the culpability of the offender, the role in the crime, the nature of the loss or the injury to the victim. There's a lot of different things that can play out that call for different sentences. And so judges have to consider that. And it's hard to put metrics to that. I think you have to have an individual consideration. There's also the offender. So, an offender who's drug dependent might warrant a different type of intervention than a defendant that's not. And so there's individual characteristics. And I build into that individual characteristic that person that has a long prior record versus someone who's a first-time offender. So there's those kind of factors. And then I think the third thing that people don't think about often is the purpose of sentencing. Judges have a lot of different reasons for doing what they do. And we generally think in two sort of categories of reasons. One is retribution. We're just holding someone accountable for coming into the system, and we're going to sort of make things even by whatever kind of punishment or sentence we're imposing. And that's way different than the more utilitarian purposes, like we're going to try to change behaviors and promote better outcomes. And sometimes those two approaches can be done sort of hand in glove, and sometimes they're very different approaches to how a judge is imposing a sentence. So I think you can think of a judge thinking in terms of punishment, and there may be a different scaling of punishment based on those individual or background factors, or just role in the offense. But if the defendant is drug dependent or has mental health issues, that might also impact the type of sentence a judge is imposing.
That's great. You both mentioned the kind of patchwork quilt of the criminal justice system in America, and how there's a lot of heterogeneity or variation across different jurisdictions. One common refrain from critics would be the challenge of bias and disparities, and somehow how particular sentencing guidelines or features of the sentencing system perpetuate those biases or disparities. Can you talk about that a little bit?
Well, I could best talk about that in terms of like the issues with sentencing guidelines, their structure, and then the disparities that can arise. And I've spent my whole career studying really two kinds of disparities. One based on individual social statuses like race, age, gender, and then the other being organizational disparities in, say, the plea bargaining practices, or the difference between conviction by trial and plea bargaining, and then especially the differences between the patchwork, the differences between places, county courts in Pennsylvania, district courts in the federal system. And the Pennsylvania and the federal system, Pennsylvania's guidelines and the federal guidelines, are a really instructive and valuable contrast, because they took very different approaches. And in many ways, I think Pennsylvania avoided a lot of the problems and controversies that beset the federal sentencing guidelines. Pennsylvania went the route of erring on the side of discretion for various reasons, governmental, political, judicial, and so forth. And giving that benchmark, but wider discretion and relatively simple guidelines, with offense gravity score, how severe, and a prior record score of weighted by the severity of criminal convictions, and then aggravated and mitigated ranges, and a relatively small number of adjustments, like a deadly weapon enhancement and so forth. And they also did not key the guidelines to mandatory minimums. The federal system went completely the opposite direction. They tried to restrict judicial discretion as much as possible. They developed a very, very complicated set of sentencing guidelines with Barry Rubeck, I think, once calculated 3 million combinations that could occur with one simple crime of federal crime of robbery. And that's because they built in all these different adjustments to the offense severity based on what they called relevant conduct, offense-specific behavior, things like role in the offense and so forth, and also departures that the prosecutors could move for, like substantial assistance to law enforcement, and an actual structured sentence reduction for that. All of which it did I don't know if it was intended or unintended, but it took a lot of the discretion that judges used to have and moved it to prosecutors, because the guidelines gave them this menu of things to manipulate and bargain about in plea bargaining, which also is to say it gave prosecutors lots of leverage to get people to plead guilty. U.S. sentencing guidelines also keyed themselves to mandatory minimums, so that a mandatory minimum, if it's sought, always trumps the guidelines. Pennsylvania didn't do that. But yet you still see in the federal system, you see big differences between district courts, where you are in the country, Southern California or Vermont or Indiana. And those differences come from how U.S. attorneys' offices manipulate those guideline factors in the guilty plea process. Pennsylvania, it faced opposite problems, but it avoided a lot of the controversies and legal challenges that the federal guidelines had, because they didn't do that.
And if I could pick up on the patchwork idea, in Pennsylvania we have 67 counties, and most of criminal justice in Pennsylvania is done at the county level. We have courts of common pleas that are generally county-based, and we have counties really funding the criminal justice system. The state puts some money in, but modest as compared to the total cost. And so you find different criminal justice systems in each of the counties. And so one of the benefits, I think, of guidelines are to provide this framework that all counties in Pennsylvania are operating under. I think absent that, you would have what we did have in the 70s and before, which was just individualized justice by county or by judge, which in some cases was very good, in some cases very bad. And so having a framework, I think, is important when you have this distributed system of criminal justice.
That's fascinating. There's so many different permutations of how justice can be applied, and I can understand how that can be incredibly controversial.
Sure.
Around what your background is, where you are, where you tried.
And if I could speak, Pennsylvania, in my research and others, including in a study that my colleagues and I recently did with the death penalty and prosecutors seeking the death penalty and people actually getting the death penalty, there are divergent practices across counties, and with non-capital sentencing, with ordinary sentences that come under the sentencing guidelines, crimes that come under the sentencing guidelines, you do see between county differences, but they would be even worse. They'd have to be even worse without guidelines, and at least there's a center to it with guidelines. It's variation around the anchor of the guidelines instead. And I think the death penalty decision making actually makes a nice contrast, because there is not guidelines that govern prosecutors seeking the death penalty and judges or juries giving the death penalty. And in our report to the state and in some publications that are coming out, we found that really, other than the presence of the statutory aggravators, which are themselves some of them are subject to discretion and perception by DAs, but the biggest thing was what county you're in, one's exposure, someone convicted of first-degree murder, their likelihood of exposure to the death penalty depended on where they were in the state. And that occurs because there's not an anchoring set of rules like there are for everything below second-degree murder.
Sure.
And with guidelines.
I'd love to talk a little bit more about studying these populations and kind of the intersection between the sentencing commission and kind of the academic community, this is really kind of a wonderful example, an exemplar of what this kind of relationship can be like. But there's lots of challenges to this population, right? I mean, data collection is complicated, especially with incarcerated individuals, those who are exiting the system as well. There's been a lot of work in this space to create risk assessment tools, and that's kind of perhaps on the horizon. I don't know, Mark, if you want to talk a little bit about that.
I have hours of that. But, so let me start with a couple of things. I think data are really important. That's like central to all that we do. Evidence-based practices or data-driven practices, whatever you want to call them. But the commission has really been fortunate, I think, from the very start. We've been focused on gathering very discrete information about individual cases and building up to the offender information. And so we have since probably the mid-'80s, we have data sets that I think are pretty good data sets in terms of granularity and quality. And that's really helpful in our space at sentencing. And that helps us to look at judges' decision-making and to track outcomes. But what's equally important in having good sentencing data is to be able to match it with other parts of the system. And so in Pennsylvania, I think we're really fortunate. We have at the enterprise level in the criminal justice system an application called JNet, or the Justice Network, that allows criminal justice agencies to share information. And it really promotes the ability to match cases across systems. So we have the ability with work that we do internally or work that the department, Jeff, others do, that we can connect our data through some unique identifiers with Department of Corrections, the Parole Board, Pennsylvania State Police for rap sheets, and other criminal justice agencies. Where I think there's probably a weakness is the more interdisciplinary areas where we really are interested in, like, the intersection of criminal justice and health, and sometimes because of confidentiality and other things like that, or because we have different sets of identifiers, it's sometimes hard to do as good a job as possible of connecting all those things and knowing what works and what doesn't. So that's probably a challenging area. But I think, like, within our own space, I do a lot of work in other states, and I see how sort of blessed we are to have this sort of great quality data and interconnectivity within the criminal justice system. If we can build on anything, it would be to have better connections outside of criminal justice.
Yeah, that's fascinating. That a system that is inherently disjointed perhaps has then more of an effort to combine and integrate their data.
Absolutely.
As a result, because there's a big piece there. And I know that from some of our work, there's been major technical strides in doing some of these linkages across different identifiers, but much of the challenge is getting the trust in place, the relationships in place, to ensure that everything will be protected and confidentiality will be maintained, and privacy maintained, and ethical use, of course. Jeff, you have any points on kind of studying this population?
Yes. Well, so we have actually first of all, the research we've done and I've done over the course of my career has only been made possible because Pennsylvania's Sentencing Commission and the federal system, with sometimes less willingness, but because they collect and provide data. It astonishes me that more states don't have sentencing commissions, and more states, there are states that don't have a central repository of data that you can analyze to look at that state's sentencing in 2020. Several states. So from in guideline states like Pennsylvania, and Pennsylvania's data and commission are they're national leaders in the data collection and dissemination and care that they take with the data. So once somebody's convicted of a crime, we have excellent data on what happened, what their characteristics are, what their crime of conviction was, what their criminal history was, what sentence they got. And then it's not as accessible, but there is good data from the Department of Corrections that it's not obviously as public because it's got privacy kind of information. But researchers can fulfill certain requirements to get it. And then the PCS and JNet, have the opportunity or ability to kind of trace somebody post-release. What we don't have, and this is true nationwide, what we don't have is good data or even good ways of getting data prior to that conviction process. So if you want to trace, like, what were the original charges that that a defendant had filed? What were their arrest charges? How did they change? How did the charges change from arrest to charging to conviction? And so you can look at the plea bargaining process, bail, pre-sentence detention. If you want that information, you kind of have to collect it yourself from, depending on the state, from the courts themselves, or in Pennsylvania, we do have the Administrative Office of Pennsylvania Courts, which has docket transcripts online. But if you know the case number, you can look it up yourself and code it yourself, which is what we've done with we had to do that with the capital cases. And that's so much, if there's a black box in criminal justice case processing, that's it.
In recent years, they have been, I think, working on this area that Jeff talked about. We've done some research where we're able to obtain data sets from them for arrest and do, in effect, an attrition study of all of these charges and were they disposed of. But it is a lot of work, and it's not as easy as it should be. And also, the point I think that we both made previously was that even if you have those data from AOPC, there's a lot of individual detailed decision making happening at the local level that's probably not captured in that. So you still have to do a lot of primary research back in the county to try to figure out what's going on. I did want to mention just one other thing, because you raised risk assessment. The commission spent about 10 years on this, and it's very contentious space right now. But in looking at risk assessment, one of the major areas of pushback was the quality of the data and the bias in the data. And I think what we found was that's particularly true when you're talking about arrest data, because you're really reflecting law enforcement practices about where you're deploying police and what kind of arrests are being made and what have you. So there has been a lot of pushback in terms of what's often labeled as tainted data, and especially around arrest data. And so at least for our efforts around risk assessment, we had to move from arrest data to conviction data, and then do other work to try to, in effect, neutralize race in terms of considering a lot of those kind of factors.
Yeah, it's fascinating considering the Democratic debate last night. I think stop and frisk was remarkably high in discussion, and that has implications downstream in the. I mean, this is where the patchwork quilt of criminal justice agencies across the state in Pennsylvania, the Commonwealth, but also across the country. Then it really creates a lot of variability, which makes studying very challenging. And also, it's interesting to think about how the implications for the study and the practicing of sentencing has ripple effects across society in different ways. There's, I think societally there's a rebuttal against the mass incarceration that is perceived. So it's interesting to think if there are ways to, we've been kind of zoomed in our discussion on the particularities of sentencing, but how does this work really touch on the larger society, both in the United States and then I think in international context too, if you have any insights there?
Well, I guess a couple of things. One is, if you start with the mass incarceration or those kind of concerns, a focal point is sentencing. What is happening in terms of driving people to incarceration. Now, there's been work, I think, in recent years through justice reinvestment and other things to try to maybe turn the corner on that and start to bring it back. I know we at the Commission are spending a lot of time looking at our criminal history, because if you think about it, whether you're thinking about the use of prior convictions as some kind of measure of culpability or something like that, that's going to drive up sentences. And if you don't have some kind of, if you don't revisit that at some point, those criminal histories remain with you for life and they drive up your sentences. And if you look at the intersection of that kind of retribution with risk, older people are going to be at much lower risk, but they're going to hold on to that prior record score. And so we have to look at how we adjust that to accommodate sort of consideration of risk factors. The converse side of that, I guess, is that younger offenders tend to be at higher risk. So it's almost, we're the deck is a little bit stacked, because younger kids with a lower prior record score might have a higher risk factor, and then older people might retain a prior record but be at lower risk. So we're spending a lot of time looking at that whole space and trying to figure out how we can bring some balance to it and sort of right-size things. I think what we have to do as a commission, as a state agency, and also just for better, return on investment, is really just think about better outcomes. And, some better outcomes involve the offender. We want, individuals coming through the system to leave better and stay out of the system. And so we have to focus on how do you do that and what role does sentencing have in that. And then you want to think about public safety, because that's sort of job one. So how do you do the right thing with offenders to promote public safety? And they can be one and the same, right? If you're reducing negative outcomes, you're also promoting public safety. And then that gets to the issue of resources. Why are we spending money where it's not necessary? And one of the things you'll see, aside from the focus on confinement and incarceration, is the focus on the lower side of people that we place on probation. Pennsylvania has a terrible reputation for having people on probation for very long periods of time with a lot of conditions, and that leads to a lot of failures for technical reasons. And so we have to right-size that too. And the research on risk and needs and responsivity is all about trying to reduce the sort of the footprint of probation. Less is more if you have a low risk and low needs person. So reduce the time, reduce the conditions, and we have to get that into the system, because sometimes probation is seen as the alternative to jail, and therefore from a retributive point of view, we need long periods and lots of conditions, and that might be exactly the wrong thing to do for low risk, low need cases. You just need to hold them accountable for a short period of time and send them on their way. And so we have to use sentencing as a mechanism to do the right thing there. So our partnership with research really helps us to think through how do you construct that so that you're doing the right thing and promoting the best outcomes.
That's great. Do you have any points on the larger kind of societal impact? Or
Yes, well, sentencing is, I've always been drawn to it as a sociologically trained scholar, because it's social control is fundamental to society, rules and deviance and conformity. And then two, sentencing is the biggest fundamental expression of a society's sense of justice. And it's to the extent that it is seen as legitimate, that society is seen as legitimate. To the extent that it has problems, that it works for some and not others, that's a problem for the whole society. And two, another reason it's sentencing is important is we try to do so much through sentencing. I've always been kind of skeptical, like many of my criminology colleagues, skeptical of crime control through sentencing. Like as that you can affect how much crime there is in society in a large sense through sentencing people to imprisonment, let's say. But what you can do with sentencing are things like Mark talked about. Sentencing is a point of intervention for individuals to address needs that they have that brought them into the system in the first place, that led them into crime in the first place, like drug and alcohol dependence, educational deficits, and if you address those things, you will address that person's criminality. If someone is dealing drugs to support their own habit, if you address their addiction, you will address their drug dealing. And so sentencing does provide us an opportunity to do those things with individuals. And so those are three groups of reasons why and it's why I'll probably will always study sentencing.
Yeah. That's great. I think that really kind of sums up some of our conversation here. I really appreciate all your time today, both of you. Again, we're joined here today with Dr. Jeff Ulmer, Professor of Sociology and Criminology in the College of Liberal Arts at Penn State, and also Mark Bergstrom, the Executive Director of the Pennsylvania Commission on Sentencing. Thank you both for your time today. I really appreciate it.
Great, thank you.
Thank you.
And with that, we'll bring this episode to a close. Many thanks to my guests. Again, I'm your host, Michael Donovan, the Director of Policy and Outreach at Penn State's Administrative Data Accelerator and the Associate Director at the Evidence to Impact Collaborative. And this has been another episode of the Evidence to Impact podcast. Thanks for listening.